Great. So thanks for joining us today. I'm going to, just so everyone gets some context on the perspective you bring to the table, I'd like to ask each of you, maybe we can start with, we'll start with you, Matt, to do like a 1 to 2 minute introduction on you, your own personal background, a bit about the company, and sort of what stage you're at now.
Great. I'm Matthew Price. It's great to be back. I'm a CBS alum, class of 2009. Oren was aware of my first foray into entrepreneurship since I sort of blithely emailed him and pestered him to get a meeting to talk about a term sheet that I had in hand with another university. The background of that is the Great Recession. I graduated without an offer from CBS. Like many of my classmates, you'd be shocked to know, especially if you read the public information from the business school. And basically took opportunities that I was seeing among companies who were struggling for early stage funding or help to a mentor who was on the faculty here named Robert Fallon. In the course of that, Robert said, oh, you're looking at a biotech company. I was looking at a company on Long Island, and it was mired in a huge lawsuit in China, and I was viscerally feeling I shouldn't go down that route because I didn't have the expertise or the ability to help a company out of a foreign lawsuit. So he said, well, but you're getting to understand the biotech world. Here's something I'm looking at. He was looking at chemotherapy from a university in the Midwest. And fast forward 5 years, we are partners running a small biotech based in Midtown Manhattan in phase 1 clinical development, working with the MD Anderson Cancer Center in Houston, the largest cancer hospital in the world, which seems odd for a small company, but for a variety of reasons we could be able to work with them. 2 other centers in the US. We've got operations in 7 countries and are still kicking.
And you've got a PhD in biology, a law degree, and you were in private equity before coming to Columbia, right?
None of the above. In fact, I'll even tell you, so I came as a J-termer doing the illegal thing, which is a career transition as a J-termer. I'd been in the nonprofit world before this. My experience had been in producing music at Lincoln Center. And what I found is working as a producer and working in early stage entrepreneurship have very similar components. Ironically, I firmly believe that the film industry and the pharma industry are merging in the way they operate in very, very peculiar and analogous ways. So I was able to translate those skills, but obviously thanks to Columbia and some more education.
Great, thank you. Vishal.
Okay, so I'm a faculty here in the computer science department at Columbia. I've been here 14 years now, I guess. It's been long. The company I started, it's called Infinio. It grew out of some research that we had done in our lab, and I negotiated with Oren 4 years ago to get the license. I think both of us were 100% happy.
We're still smiling. He still comes to my class. I don't have to pay him too much to come here. Oh, sorry.
Under the table. So before that, as a grad student, I sort of accidentally started a company. I didn't know that I was starting a company, but we were passionate fans of the sport of cricket, and we ended up starting this website called Cricinfo, which ESPN eventually acquired, and it's still today the world's most popular sports website. So that was a very different experience from what I'm experiencing right now. Infinio has now grown quite a bit. 4 years ago it was Oren and me negotiating. Now we have 2 offices in Cambridge and Nashua. We have 70 plus employees. We're going towards 100. We have been selling our product for 5 quarters now. Things are going reasonably well. So.
And how many rounds? Just funding rounds and.
Okay.
So. As of today.
As of today. I can confirm 3 rounds.
3 rounds. You can neither confirm nor deny anything else.
Yeah.
Great. Thank you, Vishal.
Yeah, sure.
Okay, Seth.
Well, good morning. I'm Seth Tripper. I'm currently with Yahoo, part of Labs and Academic Partnerships. There I have 2 primary focuses. One is on establishing and fostering collaboration with top research universities. The other being identifying technologies and companies for collaboration and/or acquisition. I've been at Yahoo for just over a year. Prior to that, I'll share with you a little bit about my background. Spent the first 10 years as an engineer at AT&T and IBM. Went to grad school, got involved in licensing out technology at a university. We developed the technology over a couple of years. We exited that, started another company, a different industry. And in fact, the first company, the exit was large in part due to the intellectual property of the company. Second company we started, exited about a year and a half ago, again, largely due to its intellectual property, was able to have an exit there. Over the course of the last 15 years, been involved in tech startups, been working with universities to help them license out technology and spin out companies. So really interested, really excited about the entrepreneurial scene and intellectual property and its benefits to companies. Thanks.
Great, thanks.
I'm Greg Blonder. I originally started at Bell Laboratories as a staff scientist, and over time ended up running a number of the labs, including starting a human factors as well as a material science group, and through an odd sense of circumstances ended up becoming the chief technical advisor for the corporation, running around trying to explain that the internet is coming, and it takes a beer to find out what really went on there, but it was an interesting time. And that was, a modestly successful run. And in a large company like that, you can influence it to save $1 billion here or $1 billion there, but when they're doing $50 billion, you feel like you haven't done your job. AT&T divested itself. I joined AT&T Ventures, which was a venture capital firm which had the name from AT&T, but was otherwise unaligned, although they were a limited partner in the first fund. And then after that went to Morgan Thaler Ventures, which I think was the third oldest venture capital firm in the company. And I don't know whether Oren has ever explained this to the class, but Dave Morgan Thaler there pioneered the rule change which allowed the prudent man rule to be changed. And then when the prudent man rule was changed, venture capital increased in size by a factor of 10. So it's very interesting to look at the history of that, because up until then, large institutional investors were prohibited from putting money into a risky asset class like venture capital. And after the prudent man rule was changed, it was imprudent not to put money into risky investments in order to ensure you had enough return for your investors. So there was almost more than a factor of 10 capitalization change after that rule change. I worked at Morgan Thaler Ventures for a number of years. I started a number of companies spinning out IP, sometimes from universities and other people. I also ended up becoming the relief pitcher operator to run a few firms that ran into trouble and needed to be bailed out. And for the last 4 or 5 years, I've been doing my own startups, as well as licensing things to companies, including as seen on TV corporations, which is an interesting run.
Great. So whoever feels like jumping in first, I'm interested, when you started your company, you probably had a sense of how critical the intellectual property was that you had at formation. And I'm guessing that that road didn't always necessarily follow the path over time in terms of the criticality of that initial intellectual property versus follow-on intellectual property, or versus intellectual property at all. So I'm interested, sort of from whoever wants to jump in, when you were sitting where they're sitting and thinking, I'm going to launch a company someday, I've got a cool idea. How quickly did you come to the idea of, I need to find my patent and I need to make sure it's a strong patent?
Well, I guess in my case, in the first company, we had licensed technology out of university, so that was the kind of the basis point of starting that company. But we knew we were going to need to develop additional intellectual property and surround that patent. It was very important because it was early stage technology. It lent itself to a number of applications in very kind of high profile areas. So we held a lot of importance on the intellectual property of that particular company. In the second one, similar initially, but a little bit, it shifted a little bit down the road. Whereas it was of importance to us to have intellectual property because we started out developing some sensor technology for the wearables industry. And then through the course of the operations of that company, determined or became much less device agnostic and more of a kind of a web-based platform. So the patent per se wasn't, we didn't hold the same level of importance although it turned out at the end of the day that was the vehicle that enabled an exit. So what we thought might not be as necessary turned out to be still fairly important.
I'll come back to that story later. That's an interesting one, but yeah.
So in my case, we routinely disclose new ideas and inventions to CTV, and then CTV goes through its own process of whether they should file a patent or not. So for Infineo's case, Infineo used to be called Silver Lining then. We had to change the name because this movie came out. And
But actually, it was a very cute name because it's a cloud computing company, right? So every cloud should have one.
that was the logo, but we had to change it.
Yeah, it's a shame.
So, but I think it was around
Trademarks.
October 2010, we disclosed to CTV, and then you went through your process, decided to file a patent. And then when the student had actually implemented the idea and when we saw the results of, this thing really works, that's when I thought that, maybe we should go out and build a company around that. So that was about 6 months after that, late spring, early summer of 2011. And then we filed, the patent had been filed. I started talking to venture capitalists. We raised our seed round. And at that time, I thought, okay, this is a great idea. This is a great product. There's no question that it's going to succeed. So after we raised our seed round, then we started talking to potential customers. And then sort of the direction changed. We realized that what we had built was great in terms of demoing a concept, but it was not the product. So after talking to customers, we sort of started evolving our thinking. And then I would say the first patent was extremely critical in getting first round of funding. And then it was very helpful in thinking through the subsequent patents. It sort of put us in the direction where we have to go. But being in academia, you don't interact with industry so much. With that patent and with the initial round of funding, I started talking to industry and customers and realized that the actual problem was slightly different from what we had thought. So the patent was critical in the sense that it helped us to get started. But as you said, the direction changed slightly. And for us, it was really first contact with customers.
Did you end up filing, has the company
Yeah.
filed many more patents?
We have filed 2 more patents.
2 more patents.
2 more patents, yeah.
Okay.
We're about to file more, but 2 have been filed then.
I was going to say, in my experience, it's very situational. In most of the social media companies, it's irrelevant. They may have patents, but it really makes no difference at all to the outcome of the company. In biotech, it's the 100% of the game. In most of the companies I've either founded or had close relationships with, it helped convince the VCs that they were buying an asset. But in fact, it had almost nothing to do with the company's success. And in general, you don't have the funds to defend it if threatened. And there's multiple ways of doing things. And I was just thinking about that because I was looking at the screen. And does anyone have enough science background to know why there's that curved wire along the edge? It's called a catenary. It's the shape that the Brooklyn Bridge takes. And it puts uniform tension across the screen. And it's a very popular way to do these things. But there are 5 other ways to make a screen. And what usually happens in most of the companies I've been associated with is you have your IP, and people just do it some other way. And the fact that your IP is nice, and it has some value, but it really, at the end of the day, except in some things like biotech, has nothing to do with your success, to be honest.
So you mentioned something, Greg, that I want to follow up on. We showed one of our startup companies, of whom we are very proud, was on Shark Tank a couple of months ago. And in an effort to explain how to do due diligence on patents, Tim, one of our senior fellows for our office, showed the clip of the classic shark. You guys have seen Shark Tank at least once, I suppose. So showed the clip of the sharks interviewing the company, and they got to that great moment that happens on every panel where someone goes, "Do you have a patent on that?" And the entrepreneur goes, "Yes," and they go, "Great," and then move right on. So my question is, in your experience working with investors, and actually I don't know if any of you have investors in the room for your companies, but if in working with investors, How savvy were the investors about the IP that you had? Did they do a ton of due diligence? Was it sort of a nice to have?
Let me give you one story,
Yeah.
which was my introduction to venture capital. So I was a young VC starting at AT&T Ventures, and I went out. We were co-investing with a well-known venture capital firm, who I won't name, with a very well-known, successful investor. And we went out to look at the company. Now, I went along as kind of the techie guy to evaluate the technology. And at the end of the day, we liked the company, we liked the founders tremendously, and we put money in it. And on the way back on the plane, this well-known VC asked me, he says, "So, what do they do?" And I said, "Excuse me?" He says, "I really don't understand their technology." I said, "We just put $5 million in between the two of us." He says, "Yeah, but I do pattern matching. I can tell that the founders walk the story, that they're the kind of people I want to back. I know the market's exciting because I've spoken to a few other people. I don't really understand the technology, and I don't really need to understand the technology." And I will tell you that is 95% of the investments I'm familiar with, that someone needs to put a check mark on that, but the investors themselves really don't understand the technology. In most cases, I want to say.
Were they right? Did the company work?
Oh yeah, it's great.
The company worked.
Great. They're absolutely bang on. That kind of pattern matching is very successful in venture capital.
So I'd love to take, you'd mentioned in biotech it's 100% of the game. I'll take that perspective on. We, at the time of licensing, or I should say beginning our licensing negotiations, obviously began to look at the patent portfolio. We immediately engaged IP counsel because the complexities of defending a molecule or a family of molecules are so intense. What we found after some diligence was that, in fact, the issued patent that would have fulfilled that question with a yes, do you have a patent? Yes, right, had some hair on it. So we actually engaged in a process as licensees who had not licensed yet in removing the hair from the patent. That was done in a collaborative way with the university, where we basically said to them, look, you guys have gotten this far, but our counsel is saying there are X, Y, and Z issues. We'd like to address those. Otherwise, we're really not going to be able to move forward. And we sort of got their blessing to do that. So in our world, we would not have taken the next step unless we had, some assurance that, in this case, it's the composition of matter, right? It's the actual molecule and the composition claims behind it that are critical. And so the question in biotech with investors is usually, do you have a patent? Yes. Does it include issued composition of matter claims? Yes. And then you've sort of fulfilled that box. The complexities can go way beyond that, as we've obviously, later found and engaged in the process of building out the portfolio, of dropping certain claims because they're not relevant to where we're headed. But I would say the investors are looking to check boxes. Even in our world, the diligence rarely goes into the actual patent claims. They'll more likely want to read a freedom to operate opinion. And they'll either ask us for ours or they'll generate their own, or both.
So freedom to operate, just as a refresher, is not the strength of your own patent necessarily, but what does the rest of the patent landscape look like? And can you do what you want to do without running into someone else's rocks?
So in my case, the patent had already been filed by the time I spoke to VCs, and I closed my seed round even before we had the license agreement with Columbia.
Which is not best practice.
Which is not red, but things moved quickly. So I would say that my seed investor from a very well-known VC firm, Kittu knows him well, he was actually very involved in the licensing process. So he deferred to me in terms of, does a patent cover the technology? But he was very involved in the licensing process. Okay, what rights does it give us? What rights Columbia has? And he helped us think through the 10 next steps of what could happen in the future. You have to make sure that this happens. You have to negotiate this and that. So he was very, very careful about negotiating the patent license carefully. He did not delve too deeply into whether the patent covers, freedom to operate, things like that. But the licensing process, he was.
I should say that most VCs are very lackadaisical after they put the money in. that I always have a patent committee with each one of the companies I put money in, so I have my other hat on. But because in many cases, when you back the company, there are other patents sitting in the patent office which have not issued. And they can show up in your third year while you're busy trying to bring revenue to market if you're not watching. And it's amazing how many companies don't watch. They don't monitor that. And you need to keep it fresh if you care about IP. If you don't care about IP, then you can be like
Did you do that yourself, or was that something you outsourced to patent counsel?
It depends on the company, but we actually do it ourselves because we tend to have more, because at that point it's a very narrow domain knowledge kind of thing, and you often know who's likely to be filing, and so you kind of watch out for them. And these days you have to watch out for international patents too. So if you believe it's real, act like it's real, you know?
I'll just add one thing to it, because more of my experiences have been mostly with the angel investors, and it is about checking off the box, and while they wanted to see some intellectual property, didn't do a great deal of due diligence in it.
Okay, so 3 of you licensed technology from universities that wasn't your own technology. So Vishal, I'll keep you out of this one just because it's a very unique situation when you're licensing your own technology from your home university where you're a tenured faculty member. There's definitely a different flavor to the negotiations that happens there. But for those of you who've looked elsewhere for your big idea, so maybe didn't have the thing yourself at the beginning, but still founded companies that went on to be successful, how did you find, I'm interested both in how you found the patent that you wanted, and then a little bit about how the negotiations unfolded with the universities, and sort of, did you do it yourself? Did you bring in a lawyer? How did it go?
Yeah, I'll talk a little bit about that. So, I think I've spent some time at universities helping them license out technology, and there's an awful lot of intellectual property as an asset at universities just waiting for individuals to come forward and license and start out companies, or being able to offer to existing companies. So those assets exist, and you could search through the portfolio and look for what you're desiring to continue with. But
for instance, techventures.columbia.edu has 1,000 patents available for licensing.
Yeah. So in my case, it was a little bit different because I was at grad school, and the university had some technology that was developed there by faculty, and they were looking for individuals to kind of assess the technology, identify applications. And not too much more than that. Myself and some colleagues got together. We suggested that we would look into it and spend a couple of months assessing it, and presented our findings to faculty, the president, et cetera. Suggested that we spin out a company, and we did just that. So it was a little bit different scenario. But the negotiations we did ourselves with the licensing department and the university. This was early. This was maybe the tail end of the 90s, actually mid-90s or so, mid to late 90s. So this was early in licensing out for that particular school. So we kind of pioneered that. I think that maybe the bit of advice is to really know your intellectual property, to know the market, so that you could develop a fair license agreement and a mutually beneficial license agreement for both parties.
We do it a couple ways. It's a very low yield process, to be honest, and a lot of VCs won't bother because it's a lot of energy for a very small yield. But a couple things. One is when I was at Morgenthaler, we were very close to SRI, and we would meet with them on a regular basis and see what they have that was good, and we would and we actually spun out Siri. Well, the voice technology that Apple bought that became Siri. Apple doesn't do a lot of technology stuff, really. They acquire things. But so that was successful, and but more likely what we do is we know a professor in the biology department who just found a really cool small molecule which has immediate applications, and we chase them. So you read the literature, you go to the conferences, you do that kind of things. The difficulty is, Columbia aside, I will tell you most universities are still in the medieval era when it comes to license terms and conditions. The professors, Columbia aside, have often extremely unusual ideas of what a license would look like and what their role will be. And so there's a lot of work and a lot of hand-holding, which a lot of people rightly don't want to spend. We much prefer a really great young CEO comes to us with a license he's already spun out and he's already had first customer contact. Why would we want to go through this trouble to work with a university? This is a much better situation to be in, and quite frankly, we can pick and choose amongst those. So we do it. It is a lot of work. It really is.
Well, in our case, it was actually serendipity, and we often ask ourselves, if and when, hopefully, we are able to succeed with our current asset, how in the world will we find the next one that's, has the same degree of quality or more? The serendipity was that Robert Fallon, whom I mentioned, my partner, who was on the faculty at CBS, was on the board of trustees of the foundation of Ohio University. So, in other words, the fundraising vehicle for a public university that's a separate entity, and he managed their investment committee, et cetera. So at some of those meetings, they would put forward some of the leading lights of the university, and one of those happened to be our inventor, who was at the time the vice president of research, and he spoke about his great drug, and basically everybody but Robert, was sort of sipping their Chardonnay and eating, and he was kind of glued to the screen. And so it really was serendipitous, and a month or two after that, he approached me to ask if I'd help him sort of go through the process. So we didn't actually seek it out, and I think in that sense, it's maybe an unusual story, but of course it can happen that way. And I think, being open-minded about these things is equally important with being diligent about what's underlying something that you like in terms of the IP.
So I'm going to make this the last question, and then we'll swap panels. When you were finding an attorney, sooner or later, I'm assuming each of you had an attorney.
Sooner.
So either on the licensing side or on the patent side or both. And so if you could talk for a little bit about your experience in finding the attorney and like some lessons you might pass along about how to work with your patent attorney, what the role of the entrepreneur is versus the company, or things that you wish you'd known then that you know now, whether it's for the patent you licensed or the patents you developed thereafter.
So for the patent, the initial filing, the patent was done by Columbia's attorney, and so I didn't have any role in finding that attorney. For licensing, initially the negotiations were done by the firm of the first law firm that I hired. We subsequently changed law firms due to a variety of reasons, but I would say the biggest one was geographical. The company started here, moved to Boston, and we went with a local Boston firm. And then I dealt with the licensing person in both firms, and I found experience really matters. In the New York City firm, the person who was dealing with it was a young attorney, didn't have too much experience, and I would say was kind of sloppy. Whereas the other firm, they were very careful about everything, billable hours and all that aside. But they zoomed in on the important stuff, which I felt were missed. And what was also happening was at that time the New York City firm was negotiating with sort of the Boston firm, which was representing our Series A investors in Boston. And sitting on the sideline, watching them negotiate, I just felt that, that the other side seemed a lot more diligent about stuff, a lot more skilled.
It's never a good feeling at that moment.
So I was happy with my main attorney, but the licensing person. So that sort of made me decide, okay, time to switch.
So you switched.
Yeah.
Anyone else switch attorneys ever?
Yeah, I think through the course of the years, as was just mentioned, I think it comes down largely to expertise in a particular area. We had worked in medical sterilization technology, to sensor technology, to software, and can you find the one firm, the one person, the two persons that can span that breadth of disciplines, or do you possibly switch when it makes sense, or work with more folks than more firms than one. But so we definitely switched from time to time where needed.
In our case, it really, so the relationships were built through pre-existing relationships. Again, call that serendipity if you like, but it turns out that the specialization in our world is enormously valuable. I mean, to give you an example, our IP council in Princeton, we work with two guys principally. One is a MD, PhD, hematologist, oncologist, who trained and worked at Mount Sinai and then did his JD, and he's a patent attorney. His partner is a former PhD synthetic chemist from Merck. So, I mean, we're working in oncology with a small molecule. I mean, the degree of specialization, it's insane, right? And so, from my perspective, I would just say, you know, you've heard a story of how the lack of specialization can give you some discomfort at times in the young life of a company. So be aware of, you know, who the right people might be, or if somebody's just trying to sell you on getting their business as an attorney.
Well, I've worked with a lot of attorneys over the years, and I'm very picky on the attorneys. You need ones who are business savvy, because we're in business, and that's what they're there to do. They're not there to show how smart they are from law school. And what I look for most in an attorney is someone who helps with claim construction, because claim construction is ultimately what allows you to defend yourself. And I want them to design claims that are defendable, that are licensable later, and are broad enough that if the company pivots, and about half of all companies pivot directions, that the claims cover the new direction they're going in, that they didn't construe them too narrowly. And so there are some attorneys who are really good at that and are broader than the original field, and there's some who write, because there are different philosophies in claim construction. There's some who write very narrow claim sets because they believe that's the best answer. There are some who have a tiered claim set. There are some who have kind of multiple layers. I have certain philosophies I like, and that's the kind of attorneys I look for because it's proven to be successful. But if they don't care about the claim construction, you get another attorney.
So I'll make your attorneys happy for a moment, and then we'll swap panels. If anyone has a firm or an attorney at a firm that they particularly liked and wants to give a shout out, we had people in the room ask for attorney recommendations previously. So I'll leave that open, but if you don't say anything, that might speak volumes too.
We are very happy with Goodwin Procter.
Goodwin Procter.
Yeah.
Okay. Goodwin Procter is one of the firms that is on our website on the recommended attorneys list that has fixed fee and deferred fee deals for university startups. So if you go to the Tech Ventures website, you can find their fixed fee deal.
We've used Goodwin Procter, and of course, sometimes you pick your attorney as well. And Lowenstein has been pretty successful on the patent side.
An attorney from Lowenstein teaches a class at the business school, actually, on new ventures. Yeah, yeah. Great. Thank you very much. So what we're going to do now is we're going to just take probably a minute to switch these mics. And then we'll have the VCs up here. We'll do the same thing, so we can do the swap now. Keith, maybe I can ask you to come down. If people want to just stretch for a minute, this will just take a sec, and then we'll do the same thing, and then we'll do a Q&A.